Disclaimer: the opinions expressed by Jacob Robinson in this video are solely his own and do not constitute legal advice nor the opinion of McCarthy Tetro. Is this something that you've seen to Canada's benefit? Is there some sort of benefit that countries that may be passing more regulation have been more definitive in their stances on it are seeing because the U.S. is kind of quote unquote dropping the ball here?
Definitely. And it's something I think countries are beginning to capitalize on because they realize the inflow of economic activity that results in it. Canada was one of the first countries in the world to offer a Bitcoin-backed investment fund. And the lawyers that I work with, one of the lawyers I work with was part of the team that helped make that a reality. And we see in the US, the ETF, the spot ETF for Grayscale still hasn't been approved. They're still going to court. Meanwhile, in Canada, we've had this for years, and investors can hold it in their registered accounts. They can hold it in tax-free savings account and benefit from the returns there. So we have seen a huge amount of capital inflow for that. We also have regulated staking. So in Canada, you can access through a registered crypto asset trading platform staking services, and you can be confident that these staking services are following all the rule of law. So I do think it opens a huge opportunity. The difficult part is, and what's interesting about the US and most markets in the world, is since the advent of electronic exchanges and alternative trading systems in the late 1990s, all the rules in place now pertain to anyone offering services to individuals in those jurisdictions. So even if you're based in the US but only offer services to Canadians, you'll be regulated by the Canadian securities regulators if you're offering products that are deemed to be securities. So that makes it interesting in that, yes, you can come to Canada and set up and build a service in a compliant manner here, but who can you market to? Can you get access to customers in the US? And we haven't seen that case. It's often this domestic approach to law, which of course is the way it works around the world. But I think crypto has really pushed the law towards a even more unfortunately, more centralized method of governance. We see things like the travel rule, and there's FATF, and there's all the World Education Fund, and all these different entities that can act as a global regulator, which might not necessarily be the best thing for the world. I think there is something to be said about being able to vote with your feet and move to countries where you agree with the laws more than others. But what crypto in Canada specifically really does is we have a path to registration for crypto asset trading platforms. So in March 2021, they issued Staff Notice 21-329, which essentially said, crypto asset trading platforms, come in and register. And the basis of that was that they held, and this was after Quadriga, which was a big black eye for Canada. So a lot of focus was on the custody of the crypto by these crypto asset trading platforms and the custodians, and a real focus there. And so what we saw was regulators taking the position that the assets themselves might not be securities. That's up to the platforms to decide. But the relationship that the customer has to the asset, meaning the customer themselves doesn't get the asset delivered to their wallet, but what they do is they have an underlying contractual right to the asset that's held on the platform of the crypto asset trading platform. So you don't, like when you hold Bitcoin on one of these platforms, you're not actually, their argument is that you're not actually holding this commodity. You're holding a derivative or a security, something, and they call it a crypto contract that evidences your right to the asset. And then when you move it off the platform, then all of a sudden, now you have that commodity.
How does that vary from public equity, like stocks?
It's different than stocks because they have two carve-outs. So when it comes to something like a crypto contract, or a crypto trading platform, there's two rules that pertain to them. There's a lot of rules, but there's two things that regulators said would make these platforms subject to securities laws. First would be that they're trading in a security or derivative, so something that would obviously bring them within the jurisdiction. That's something that's traded like a share that has dividends and things like that. The difference between a crypto contract and a security, though, is that the underlying crypto itself can't be a security. So what regulators say is that you're either trading a security and therefore we have jurisdiction, or you're trading a crypto asset that isn't a security. And we have an enumerated list of securities that include evidence of indebtedness, notes, equities, bonds, etc. If you're holding a crypto asset that doesn't fit within any of those definitions, and that's up to you, crypto trading platform, to determine whether or not it is, If you say that it's not a security and you do choose to list it, but you don't effectuate immediate transfer of the asset, then all of a sudden now what you're doing is a securities, not a securities offering, but you're subject to securities law because you're giving access to investors who are purchasing these quote unquote securities. Therefore, you're subject to our jurisdiction. So the big difference is that these crypto contracts aren't evidencing security. Now, whether that can stand up in court is still something, frankly, to be seen because there hasn't been any litigation on this. And most of the law we've seen has been not official law. It's been through staff notices, which are pronouncements by the staff of the Canadian Securities Administrators saying they're basically giving their opinion on the way securities rules should apply to crypto assets.